May everyone please make their way to their seats as the ceremony will commence shortly. If able, please be upstanding for the arrival of the ceremonial maces. Please be seated. I would like to begin by respectfully acknowledging the traditional custodians of the lands on which we gather today, the Gimuy Walubara Yidinji people. I honour your deep and enduring connection to country. The local profession is fortunate to have your wisdom and guidance at this event. I pay respect to your elders, past and present, those who have held knowledge, culture and language with resilience and power. I pay respects to your emerging elders, the next generation of storytellers and cultural leaders. I extend this respect to all First Nations people joining us here today and who may be linking in on the lands and islands on which our courts sit and circuit. I would like to welcome our dignitaries, our far northern Judge of the Supreme Court, the Honourable Justice Henry, the Honourable Justice Crowley of the Supreme Court of Queensland, District Court Judges, Her Honour Judge Fantin, His Honour Judge Morzone KC, and Chief Magistrate, Her Honour Judge Brassington. Thank you. Cairns weather is putting it on for us today. I welcome their honours Magistrates Brown, Pearson, Morton, Dalton, Walker, Lodziak, Johnson, Heggie and Mioli, and also Coroner Stephanie Williams. I extend this welcome to the Honourables Jess Pugh MP, Assistant Shadow Minister for Youth Justice and State Member for Mount Omni, Peter Russo MP, Assistant Shadow Minister for Justice and State Member for Toohey, Terry James MP, Member for Mulgrave, and Michael Healy MP, Member for Cairns. I too welcome Commissioners Cezark Mazza and Tammy Williams, Director General of the Department of Justice, Sarah Cruikshank, Deputy Director General of Courts and Tribunals, Brigida Cunnington, Mayors, Richard Suter and Alistair Gibson, members of the profession, registrars and court staff. Thank you for your attendance today. My name is Tegan Williams and it is a privilege to welcome you all here this morning. I'm a proud Yamatji woman who was born on Larrakia country and now live and work here in beautiful Gimuy. I've practiced in this region for a number of years and more recently have moved into the role as a child advocate legal officer with the Office of the Public Guardian. It is in this position that I am reminded daily of the importance of the acknowledgement that I just made earlier to our children and young people, our emerging elders. I, like many Aboriginal and Torres Strait Islander children, grew up fearing the very system I work within now. This fear wasn't unfounded. It was shaped by a long history of injustice and exclusion. It was also shaped by what I didn't see. I didn't see First Nations solicitors, barristers or decision makers. And there was a shared feeling that no matter what we said, it wouldn't be heard. Now I have the responsibility and the privilege of helping to give children and young people a voice, particularly in the child protection space. This is an area where our First Nations children are significantly overrepresented. And this representation It is not just numbers. It is stories of disconnect, of trauma, and of people, practices, and systems that too often fail to listen. But when we listen and truly listen with our practices, our decisions, and our systems, it sends a powerful message to our children and young people that your voice matters, that your culture matters, and that you matter. So when we reflect on the opening of the law year that is past, and the one that lies ahead, I would also encourage you to reflect on your knowledge of our history in this space, because it shapes the way that you practice and the way that you interact. And every interaction, especially with a child or young person, leaves a mark. That is why ceremonies like today are so important. This is an example of the growing representation of First Nations people at all levels and illustrates the strength and partnership of the people who have always been the traditional lawmakers of this land. And both of those things, representation and partnership, are essential steps towards a justice system that better listens, includes, and respects. In saying that, and before we move to the Welcome to Country, I would ask you to pause and honour the life and legacy of the late Gudjagudjal 4 Mile, a revered Gimuy Walubara Yidinji elder and respected First Nations leader. In recognition of Gudjagudjal's profound contribution and leadership in this very ceremony, his community and further, and in respect of his memory, and in the respect of the memory of the late Elaine Parker, Jack Thomas and Elise Carr, I invite you to please stand and join me in a 1-minute silence. Thank you. You may be seated. I will now welcome Jamarbalam Hendrik 4 Mile and Karawai Teresa Dar, who will conduct the Welcome to Country. This will be followed by the smoking ceremony, the carwow and call-out, and the coming together of the lawyer, facilitated by Maran Carl 4 Mile.
Good morning, everyone. My name's Hendrik 4 Mile. I'm from the Gimuy Walubara Yidinji clan of Cairns, and I'd like to welcome you here to Gimuy. I'd like to welcome all the extinguished guests that came here to Cairns from south, east, north and west. Also like to say to everyone who's gathering here around us, welcome to you guys as well, to remember us as well. So I'd like to say, Yunabilangaran, Dei Purambara, Gimuy Walubara Yidinji, welcome and enjoy your day. Thank you very much.
Good morning, everyone. Yundagoran, how is everyone? I am Karawai Teresa, one of the elders of the Gimuy Walubara Yidinji. And I welcome you all here today. Thank you.
ngayo pa ngola janan nganji bama balgal wunju kana kata wunju kana kata balgal yengo bulba guri nyala yengo yengo wunju kana wangi kana kata balgal nunduba ngape mundu guri ngongo nganji bama wunju kana kata yengo wunju balgal nganji bama kuri nyala yengo yengo wunju kana kata yengo wunju kana kata yengo wunju kana kata yengo wunju kana kata namo yak boleh menyengon lah boleh menganjelek kadang
wagaja bure gogal wagaja bure gogal bore bunjan mime bore bunjan mime Bijal bore wajol bore wajal wanjan garan mundo Munjugaran mundo wagaja bore bugal wagaja bore gogal bonjo bore me bore bonjol me bonjo wagaja bore goga wagaja bore gogal Wagaja, wagaja, bore, gogal, gogal, gogal. Wagaja, bunjal, bunjal, mimi, mimi, mimi. Wagaja, bore, bore, wajul, wajul, wajul. Bonjo, garan, garan, mundo, mundo, mundo. Wanju garan, bundo, mundo, mundo, mundo. Wanjo, wanjo, garan, garan, mundo, mundo. Wagaja, wanjo, garan, mundo, mundo, mundo. Wagaja, wagaja, wanjo, garan, mundo, mundo, mundo. Wanjo, 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 garan, mundo, mundo, mundo. Wanjo, garan, mundo, 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 mundo.
It's a smoke song. And the ceremony is one that is part of law. Bama law, cultural and traditional law. As the smoke envelops, it reminds us of how we are connected to country via our cultural and traditional rituals and ceremonies. The scent and the aroma that comes from within the vessel or the bidda reminds us of the connection and how important it is to be a part of country. The leaves, the bark, the resins that are collected in advance before ceremony is part of the process and procedure. This is something that as First Nations people we have to abide by. It is our legislation, legible through spirit and the context of natural law that also provides comprehension for the rest of the world via common law as a significant connection or understanding, comprehension of where we sit on this part of the planet. Laws are designed for whomever beyond country. The laws that we abide by are once again the natural laws of this country, not man-made laws to create revenue, not administering laws that operate within a different realm that can be seen as illegally occupying or usurping a country, people, spirituality, belief systems, education, knowledge, human rights. The natural laws are designed and governed by the spiritual world and the natural world. From the two brothers that provide some of these laws, those two brothers are Damri and Koyala. One brother, Damri, who is the maker and designer of the Gura Banna Moiety side. Damri and the Gura Banna people are connected to the environment, the land, the seas, waters, and the air via the summertime and wet season. This is how Damri and the laws are passed down via him to the people according to how processes exist within nature and mankind. The other brother, Guyala. Guyala is the maker and designer of the Gura Minya moiety system and side. The Gura Minya people are connected to this country via the winter environment, via the dry season. These are how our laws exist from before time into the future forevermore, according to our system and mechanisms. These are how we are connected through our clan, through our cultural region, and our neighboring families. These laws connect us through our tribal marriage system and intertwine, crisscross through DNA. The two brothers and the laws, they run deep within the veins of the Yidinji people. Also, the Konganji people across the water over those mountain ranges that we call Bunda Ganyara. Bunda Ganyara is the story of the crocodile. And we acknowledge our brothers and sisters, the Konganji. Gungari to the north, over the Barren River, is our brothers and sisters, the Jaboganji, who also fit within this law system. Our tri-nations within this area that cover Gimuy, which is the original name that the city of Cairns now lies upon, exist within these laws. And this is how we accompany each other via this connection. Also connections of song story, ceremony, language, ritual, and kinship. Kinship that is designed so that we know our obligation to each other as a society. The society of the original people. This is who we are as Yidinji people. This is who we are as the first people via the first laws. We have come a long way via thousands and tens of thousands of years upon this country. And to have another songline or storyline that exists here underneath our laws that are governed by man and the courts. We know that your law exists. And at the same time, this does not allow the usurpation of our people and connection to country. We will not be moved. Kawal ngale. We will now do kawal. Kawal simply means to call out. But we call out to the spirits of country, to the land, to the old people that reside in a place we call Wolwolboro, to come down and be present for this ceremony. Anjiba mayeng ola janan. Walabure buri anjiba mayeng ola janan. Nyundu bakana kadan. Kawal ngale. Kar. Kur. Oh. Kur. Yay! Thank you.
Thank you. We now move to the opening of the law year addresses. Professor Henrietta Marie AM is a distinguished Gimuy Walubara Yidinji elder, scholar and advocate. And I am delighted to invite you, Professor, to the stage for your address.
Okay, thank you. Good morning, everyone. It's a pleasure to once again be here for such a ceremony. I want to bring everyone's attention to the flag that holds high in front of us. It's a Yidinji flag. For the first time, that flag is being again raised here at the courthouse. And it's something that resembles, again, the Yidinji people. And later we will be going upstairs for the unveiling of a plaque which Guju, my brother, gave to Justice Henry last year, and which is now hanging in the hallway of the courthouse. Today we once again come together to pay our respect to two very different law traditions: the ancient body of customary law of the Yidinji nations and the 1,000-year-old English common law tradition of judge-made law, and to commit to walk side by side to improve the relationships and justice. Coming together to honour the memory of our ancestors and to honour the memory of Yidinji warriors who had sacrificed, fought and died to preserve the integrity of our nation. I want to once again thank the Honourable Justice Henry for taking the historic initiative to include the Walubara Yidinji people to be part of this great English tradition, marking the opening of law year at the Cairns Courthouse, a tradition which continues since colonisation in Australia, a tradition which now acknowledges and pays respect to the body of law and custom held by the Walubara Yidinji people of this land. I was asked by one member of my family why I have agreed to participate in such tradition. I had to think about it, as I was blinded by my ideas of what it would take to make this Western system of laws really understand our customs and our laws. But how would it really take into account our systems and the way it would operate in this Western British law in terms of codifying our law? Again, I am not too sure of the answer. What I do understand is the racist ideologies which were fundamental to the act of colonisation and dispossession which took place on this continent with the arrival of the British in 1788. And they have provided the rationale for the administration of Indigenous affairs ever since. British colonisation in Gimuy Yidinji territory will be 150 years next year in 2026. 149 years ago, in 1876, this land, our Jabuja, was invaded and settled by the British colonisers. We remember the massacres, the rape of our women and the stealing of our women and children, the removal of many of our people to newly established missions, and the attempt to subjugate our laws. This land we stand on today is the land of the Walubara Yidinji nation, a fact recognised by the Federal Court on April the 1st, 2021. Our customary law and Western law have coexisted in a somewhat unequal relationship since 1876. How do we strengthen and build on this to improve the relationship between the two laws? We continue to live and practice our system of law by practising the principles of what makes Yidinji and what makes us Yidinji. But how would Yidinji law fit within the Western system is the question. The history of legislation has impacting Indigenous peoples reflect the complex interplay of systemic discrimination, evolving policies and ongoing efforts towards reconciliation. From the late 19th century through to 2025, laws and institutional frameworks have both perpetuated and sought to rectify racial inequalities. While acts of personal racism can be brought to the attention of the appropriate authorities and for the most part dealt with accordingly, it is more insidious form of racism which remains embedded within institutions of mainstream society and which has the most devastating and lasting impacts on the lives of Indigenous peoples. The manner in which the federal and state government agencies formulate, prioritise, manage and resource the various Indigenous affairs policy in such a way as to ignore our rights as Indigenous peoples and marginalise and disempower us to the extent that we as Indigenous people cannot exercise our rights to self-determination over our lives is the very heart of institutional racism. To be colonised means to be affected in every aspect of one's life, politically, economically, socially, culturally and psychologically. An Aboriginal writer by the name of Kevin Gilbert summarised our experience of what it is like to be a colonised people. And I quote, "It is my thesis that Aboriginal Australians underwent the rape of the soul so profound that the blight continues in the minds of most blacks today. It is this psychological blight, more than anything else, that causes the conditions we see on reserves and mission, and it is repeated down the generations." While these words were penned 50 years ago, they still remain tragically true today. In past legislation, both federal and state provided ample evidence of the colonial regime under which Indigenous peoples of this continent had suffered. With the success of the 1967 referendum and the passing of the Commonwealth Racial Discrimination Act 1975 and the repeal of the states of their overtly discriminatory law in the 1970s, it appeared in the minds of most Australian and many Indigenous people too that the legislative basis for an equitable society had been achieved, and all that was necessary to make the wounds of the past the time is time, money and appropriate compensatory program under policies of equity and affirmative action. Queensland Family and Child Commission annual report in 23-24 stated that approximately 30% of Queenslanders are under the age of 25, and 8% of those identify as Aboriginal and or Torres Strait Islander. One of the most significant issues that warrant urgent attention and action is that First Nations children and young people continue to be disproportionately represented in statutory child protection and youth justice system in Queensland. In Queensland, Indigenous children are 9.5 times more likely than their non-Indigenous counterpart to be in out-of-home care. As such, the magnitude of disproportionate representation of both Aboriginal and Torres Strait Islander children in out-of-home care is evidence that the system is discriminatory in both design and application. The state also incarcerates more Indigenous children than anywhere else in this country. A shame. On our average day 70% of state's youth prison population is Indigenous, despite making up 8% of the state's youth. Aboriginal and Torres Strait Islander children and young people also continue to be less likely to be diverted from the youth justice system, and disproportionate representation is highest for young Aboriginal and Torres Strait Islander defendants. Where appropriate, young children and young people in conflict with the law should be dealt with in a way that does not involve the judicial intervention. Police can deal with the offenders using court action, laying charges that must be answered in court, or non-court actions such as caution, conferencing, or issuing fines. The rate of proceedings by police using court action is still significantly high of Aboriginal and Torres Strait Islander young people. In 2022-23, 87% of 10 and 11-year-old defendants, 68% of 12-year-old defendants, and 72% of 13-year-old defendants were Aboriginal and Torres Strait Islander children. In 2022-23, in comparison with non-Indigenous children, 10 to 13-year-old Aboriginal and Torres Strait Islander children were more than 45 times more likely to be under community-based supervision and more than 51 times more likely to be in detention. The disproportionate representation of Aboriginal and Torres Strait Islander children and young people in Queensland youth justice system is ongoing. Despite comprising only 8% of all children and young people aged between 10 and 17 years in Queensland, Aboriginal and Torres Strait Islander children account for 53% of all child defendants who were convicted in the Queensland court in 2022-23. And the situation is only going to get worse. We just need to see the recent amendments to Making Queensland Safer Act 2024, the youth offenders, and 33 offences under the adult crime and adult time, strengthening Making Queensland Safer laws to turn the tide of the latest youth crime. The trajectory from 1897 to 2025 reflects the complex interplay between discriminatory laws such as legislation, recognition of systemic racism, and ongoing efforts towards reconciliation. This remains a pivotal reminder that systemic racism is deeply embedded within institutional structures, requiring more than legislative change. Achieving equity for Indigenous people requires comprehensive reforms and confronts systematic biases within health, justice, education, and economic system. And the productivity report indicates the disparities persist, underscoring the urgent need for sustained systemic and culturally informed policy to dismantle institutional racism fundamentally. Colonialism is a structured relationship of the domination of the colonisers over the colonised. While this great land and seascape surrounds us and it speaks to us and reminds us who we are, they give us our laws and our custom as Yidinji people. They remind us that we must not lose our connection to this great Jabberja, that we need to strengthen the connection of our Gupi, our spirit dreaming, and create our identity as Gimuy Walubara Yidinji people, living our own cultures according to our own traditions and law in our own country. I want to echo the words, as I have done previous times, the Canadian law professor Farrell. Even if we as lawyers are delivering the most principled, correct and fearless brand of legal advice, if the justice we deliver as a profession is out of reach for many in society, the principle of equality before the law, which we fundamentally seek to uphold, will remain unrealised. A message from Yidinji and Gimuy on behalf of Indigenous people: we want to see changes in the justice system, enabling access to justice as the kind of life people want to live. Accessing equality, understanding, education, food security, housing, security and happiness without fear. I hope that we will start seeing a dismantling of racism within the institutions that serves or deliver equality to us. I thank you again for having our people as part of the ceremony. Thank you.
Thank you. For the next address, I have the pleasure of welcoming the Honourable Justice Crowley to the stage, who in 2022 made history when he was appointed as the first Indigenous Supreme Court Judge.
Good morning, everyone. I'm honoured to be invited to attend today's ceremony and to give this address on behalf of the legal profession for the opening of the 2025-2026 law year. I acknowledge the traditional owners of the land upon which this courthouse sits, the Gimuy Walubara Yidinji people, and I pay my respects to your elders past and present, and I thank you for welcoming me onto your country and allowing me to give this address today and to be a part of this great ceremony. I also acknowledge and pay my respects to the traditional owners of the lands and the waters within the vast far north region, which extends far beyond this courthouse and this place, all the way to the Cape and beyond, to the Torres Strait and to points south and west. As we are welcomed here by the local traditional owners, on behalf of the judicial officers and the courts, I say to everyone present here and to all persons across the far north, you in turn are all welcome here in this courthouse and in all courthouses throughout this region. Know that this is a place of justice for all. It is fitting that we mark the opening of the 2025-2026 law year with a ceremony. The importance of ceremony cannot be denied or underestimated, particularly for First Nations people. Ceremony is an integral part of life. The same is true for non-Indigenous cultures. Ceremony for the opening of the law year, which has been observed by English judges as a tradition, was imported and continued in this country upon colonisation and the introduction of English law. Although the origins of that ceremony date back many centuries and have been observed here since colonisation, it must be acknowledged and understood that ceremony has been a part of life in this country and on these lands for millennia. So too have the traditions, law and customs of Aboriginal and Torres Strait Islander peoples, which have existed for thousands of years and continue to be observed and practiced today. All ceremonies are different. They can be an occasion for celebration, recognition, reflection and commitment. This ceremony draws upon each of those aspects and melds traditional English legal traditions with ancient Indigenous ritual and tradition, guided and inspired by the culture, customs and the law of the Gimuy Walubara Yidinji to create a ceremony by which we celebrate the opening of the new law year, recognise the continuing authority, culture and connection to country of the traditional owners and the inhabitants of this land, reflect upon the past injustices for Indigenous peoples wrought by the effects of colonisation, recommit to a system of justice that is fair and equal for all people, and renew the legal profession's commitment to serving the ends of justice. Symbols and symbolism are, of course, a feature of all ceremonies, and this ceremony is no exception. We sometimes hear of people these days speaking of an act or an event in pejorative terms as being just symbolic, as if it's a token or superficial gesture. What we must always remember, however, is that symbols and symbolism have meaning. And that's particularly so for First Nations people. It's sometimes easy to forget. We've become so accustomed to routinely saying or doing something or seeing something done that we forget its true meaning and importance. One example is a custom we've already witnessed here this morning, the shaking of hands. That's a formal gesture that features in many cultures around the world, but its origins and true significance are not necessarily known or entirely clear. Some historians suggest that the act of two people clasping open hands without weapons was traditionally done to show peaceful intentions and goodwill. Others have even suggested that it had a more practical purpose, with the up and down shaking of the hand being a way of having an assurance that your opponent didn't have a weapon up their sleeve. Now, whether that's true or not, whatever its origins, nowadays we recognise it universally as a greeting and a sign of peaceful intent and goodwill. The meaning of the symbols and symbolism displayed in this ceremony should also be understood by everyone, just as we understand the importance and significance of the handshake. They are representative of something bigger. We saw here this morning the lawyers and the warriors meeting, facing each other, symbolising two opposing cultures, customs and traditions. We then saw the lawyers remove their robes and wigs, stripping away their formal legal regalia to show that behind their judicial office or their status as legal practitioners, they are everyday people, equals in the community who serve the community through the administration of justice. The lawyers then lay their robes on the ground, initiating an invitation to the warriors. And the warriors then peacefully accepted that invitation to join with the lawyers by placing down their weapons and shields. The final act of shaking of hands symbolised the goodwill and good faith between the legal profession and the community, and the coming together of the law in mutual respect and recognition of these two cultures and traditions. There is, of course, much more to this brief exchange and the other symbols and rituals on display here today. Again, all of which is representative of broader concepts, values and ideals, at the heart of which we recognise equality, mutual respect and recognition before and within the law. We will soon see one of our magistrates recite the oath of office by a magistrate, indicative of the recommitment by all judicial officers to do equal justice to all persons according to law. Similarly, we will see and hear one of our legal practitioners take the oath of admission as a legal practitioner, symbolising the recommitment by all lawyers to the professional discharge of their duties to the courts, their clients and the broader community. As we move forward in the 2025-2026 law year, I am sure that all members of the judiciary and the legal profession will carry with them the meaning and significance of this ceremony into practice, and that they will join with me in resolving to ensure and observe and promote equality, mutual respect for all people within our courts as we journey together on the shared path to justice.
Thank you, Justice Crowley, for your address. We move now to the recital of the oath or affirmation of office by a representative of the judiciary. This is a tradition that reinforces the responsibilities of the judiciary and serves as a reminder of the trust placed in it by the community. It is a solemn pledge and a public declaration that the judiciary will uphold the law faithfully, ensure justice between all parties, regardless of status and power, and serve with fairness and humility. In keeping with this tradition, may I call upon His Honour Magistrate Lodziak as the representative recital of the oath or affirmation of office on behalf of the judiciary.
I, Jacob Lodziak, do sincerely promise and swear that I will be faithful and bear true allegiance to His Majesty King Charles III as lawful sovereign of Australia and to his heirs and successors according to law. And in the office of magistrate, I will at all times and in all things do equal justice to all persons and discharge the duties and responsibilities of the office according to law, to the best of my knowledge and ability, without fear, favour, or affection. So help me God.
Thank you. The legal practitioner's oath is a promise that highlights the ethical and professional responsibility of those who practice law. It is a commitment to honesty, to acting within the law, and to placing duty to the court above all else, even when staunchly advocating for individuals. This oath serves as a reminder that this profession requires diligence, fairness, accountability, and ongoing learning. In this spirit, may I please call upon Nikita Celine as a representative of recital of oath or affirmation of office on behalf of the legal profession.
I, Nikita Celine, do sincerely promise and swear that I will truly and honestly conduct myself in the practice of a lawyer of this court according to law to the best of my knowledge and ability. So help me God.
Thank you. I now welcome back Jamabala Mahendrick Formile and Karawai Teresa Diwa to officially declare the law year open and to pass the courthouse ceremonial mace to the Honourable Justice Crawley.
Long before British law was established in Cairns, the Gimuy Walubara Yidinji people were already part of a complex legal system called law. Law is knowledge passed down orally. Our law refers to our culture, customs, beliefs and stories learnt from our story time and governs all aspects of our daily life. It is a guide to our understanding of our world, its origins and our place within it. It connects us to our country, our people, our ancestors, our creator beings and all living and non-living things. This is represented through our visual arts, storytelling, ceremonies, totems, kinship, dances, music and songs. All these components play a crucial role in preserving and passing on our ancient stories, often using symbolism and a representation to convey deeper meanings. Our responsibilities and roles are to maintain the natural balance of spiritual, social, cultural, economic, political, environmental, physical and knowledge systems in order for everything to work in unison for our survival and the survival of Mother Nature and leaving behind a positive footprint for our future generations. Each member of the Gimuy Walubara Yidinji family understand their role and responsibilities, as well as what is acceptable and unacceptable behaviour within our society. The punishment for breaking law is no longer practiced as British law now, hands out the punishment for our people. Our law is not static, it evolves with the changing times and the experiences of our people. It is our source of strength and resilience, Overall, it is a profound expression of our spiritual connection to the land, our ancestors, and our ongoing cycle of life. It is an integral part of our identity, our belonging, our well-being, and our worldview that embodies our rich cultural heritage and provides us with deeper insights and understandings into our relationship with nature and the universe. Our law is Jiri Budal Mudjam Jabu Jabugayim Brindo Gamundo Bando. Look after Mother Earth and all living and spiritual things. Banja Boloro Gorano follow storytime messages. Jiri Budal Bamal, care for our people. Mignu Boloro Bomba, protect sacred sites and territory. Dugal Balmban Nario Gorno, learn and pass on knowledge. Binagal Go Yundonalan, listen to your elders. Binagal Yanban Bandu, respect all things.
Now we declare the law year open.
Thank you.
Thank you, everyone. That concludes the ceremony for this morning. But before we move to the closing kawal and call out, I would like to firstly invite you to the unveiling of the Yidinji flag, which last year, in a symbolic and historic gesture, was presented to Justice Henry by Gimuy Walubara to be displayed in the Supreme Court. The unveiling will take place on level 4, 10 minutes following the ceremony. Secondly, I want to thank all the participants who shared their time and those who shared their knowledge and culture. It is appreciated. I would also like to extend my thanks to the organising committee and Justice Henry, who work tirelessly each year to ensure we benefit from this important event, and to the court staff who just as diligently make this morning run so seamlessly. Finally, thank you to our speakers, Professor Henrietta Marie AM and the Honourable Justice Crowley. It has been an honour to listen to your words today. Professor Marie, you were particularly instrumental in the ceremony and so generous with your knowledge. Thank you for your enduring commitment. Maran Ka Formail will now conduct the closing kawal and call out. Thank you.